Hi, I'm Tracy Durkin, a director with the IP specialty firm of Sterne, Kessler, Goldstein Fox in Washington, D.C. The recent Apple-Samsung litigation has consumed the media since last August, when a California jury awarded Apple more than $1 billion for infringement. Of the 3 design patents involved in that judgment, one was for a Graphical User Interface, or GUI. This landmark case is the first time that a U.S. court has considered infringement of a GUI design patent, and may be just the tip of the iceberg beginning to emerge within the design patent landscape. Design protection for GUIs has developed at a slow rate since 1996, when the U.S. Patent and Trademark Office first created guidelines for their examination. The design patent statute provides that whoever invents any new, original, and ornamental design for an article of manufacture may obtain a patent for it. How then is GUI considered an article of manufacture under U.S. law? The Manual of Patent Examination Procedure describes an ornamental design as the shape and configuration of an article, indicia, contrasting color or materials, and graphic representations on an article of manufacture. Such graphic representations are considered surface treatment, which by itself is not protectable by a design patent. It becomes protectable when it is applied to an article of manufacture. Protection of GUIs using a design patent was established in the case of In Re Stridgeland, which involved an application for an icon. The icon was rejected for not being an article of manufacture. The applicant tried to amend his application to explain that the icon was used on a computer display, and even tried to add the display to the patent application figures. The patent examiner considered both additions to be adding something new to the application after filing, which is impermissible. The Board of Appeals affirmed the examiner, but in doing so, created a roadmap of how to apply for a patentable GUI. In essence, had the information that was added to the application after it was filed been provided at the time of filing, the design would have been patentable. In 1996, the U.S. Patent Office created guidelines for the protection of GUIs based on that decision, and GUIs are now statutory subject matter, provided they're shown with some portion of a display or other article of manufacture in the patent drawings. There have been no reported board decisions involving the patentability of GUI designs since Stridgeland, and other than the Apple-Samsung case, there have been no reported infringement actions either. The requirements to patent a GUI design in the United States are the same as for all design patent applications. The design must be novel, not obvious, and not functional. The claim design may be presented as a line drawing or digital image. Color and grayscale may be patented together, but line drawings and digital images may not be. Animated GUI designs are patentable in the U.S., provided at least 2 views of the animation are included in the application. More images may lead to a greater chance of patentability, but they may also lead to a patent with a narrow scope. Examiners search prior patented GUI designs as well as GUI utility patents in making their patentability determination, resulting in a very complex and comprehensive search. While design patent applications are rarely rejected, the most common references used in a GUI design rejection are figures from utility patents. Non-patent literature is also commonly used. The number of utility patent lawsuits involving GUI is increasing rapidly in the United States. We know from information provided recently by the U.S. Patent Office that the number of GUI design patent applications is growing at the fastest rate of any other area. As digital displays become commonplace on more consumer products and smartphone apps continue to proliferate, there's little doubt that we will eventually see more litigation involving GUI design patents. Thank you.